With this talk, I begin the series on the Union Executive, which includes the President of India, the Vice President of India, various powers of the President, the Council of Ministers, the ministerial system, the Attorney General, etc. There would be 3 talks in all. And in this talk, I will discuss only about the President of India. In order to understand the composition and structure of the Union Executive as given in our Constitution, one has to have a clear understanding of the concept of citizenship and the federal scheme, in respect of which I have already given a fair idea in my previous talks. Here, it would be appropriate to introduce to another a small concept, that is the concept of the government. In the Indian Constitution, the state and the government are often used in identical senses, as in Article 13. At the same time, the judiciary is regarded separate from the government, as in Article 131, that confers original jurisdiction on any dispute between the Government of India and one or more states, or between governments of states themselves, or between the Government of India and governments of one or more states on the one side and governments of one or more states on the other. In Article 32, an implicit distinction between the two is made by conferring writ issuing powers over the governments of the Union and the states on the Supreme Court. Article 226 confers the same power on the High Courts over the government within its territorial jurisdiction. Thus, the government is composed of the legislature and the executive. Judiciary is not government. The Supreme Court of India has pronounced India as a parliamentary democracy. The model of the parliamentary government is similar to the British, except in 2 points. First, the Indian Constitution is written. This necessarily means that the written Constitution is the supreme law of the land, and the British theory of parliamentary sovereignty does not apply in India. Second, India is a republic. This means primarily that the chief executive of the Union and the head of the state is an elected president who does not enjoy the elevated status of the Queen or King in Parliament of Britain. The President of India is a part of Parliament, though she or he is not a member of any House of Parliament. Like the Queen in Britain, the President of India acts according to the advice of the Union Council of Ministers. But unlike the British Queen, she or he does not have any inherent power or prerogative. All the powers of the President are derived from the Constitution. There is no power other than any that may be expressly sanctioned by the Constitution. Like the Queen of Britain, the President of India unites the executive and the legislature. Her or his election at the same time unites the union and the states. A citizen of India having completed the age of 35 years and qualified for election as member of the House of the People and not holding any office of profit under the Government of India or of a state or any local or other authority subject to them other than the President, the Vice President of the Union or a Governor or a Minister for the Union or a state alone is eligible for election as the President. If a member of Parliament or a state legislature is elected President, she or he will be deemed to have vacated her or his seat. The President is elected by the members of an electoral college consisting of A. The elected members of both houses of Parliament and B. The elected members of the legislative assemblies of the states and the legislature of the National Capital Territory of Delhi and the Union Territory of Pondicherry. In order to achieve a uniformity of representation among the states, inter se as well as between the Union and the states, the following formula of counting of votes has been prescribed. A. Every elected member of a state legislative assembly shall have as many votes as there are multiples of 1000 in the quotient obtained by dividing the population of the state by the total number of the elected members. The remainder of 500 or more number being counted as one and added to the quotient. B. Each elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of the states' legislative assemblies by the total number of elected members of both the houses of Parliament. Fractions exceeding one half being counted as one. In this calculation of population, the figure of the last census will be referred to. The election of president is held according to the system of proportional representation by means of single transferable vote. Voting at such election is by secret ballot. Usually a proportional representation is held on the basis of a multi-member constituency with as many votes as there are seats to be filled up. As the president's post is only one, the vote of each elector is single but transferable. Each elector has as many preferences as the number of candidates. The quota for election is 50% plus 1. If no candidate reaches the quota at the count of first preferences, the second preferences of the other electors are counted, and so on. The benefit of this system is that a president has an absolute majority of votes cast even by the second preference. A president holds office for 5 years from the date of entering it, but may continue beyond the term until the successor enters the office. She or he may resign by writing under her/his hand to the vice president. A president or a past president has the right to seek re-election. Though, except the first president, Rajendra Prasad, no one has done so. She or he may also be removed from office by impeachment. A president may be impeached for the violation of the Constitution in two stages. An impeachment is a trial by the legislature. A charge is preferred by a resolution in any house moved after at least 14 days notice in writing, signed by not less than 1/4 of the total number of members of the house, and passed by not less than 2/3 of the total number of members of the house. When a charge is so preferred, the other house shall investigate or cause to be investigated the charge, and the president has the right to appear and to be represented in the investigation. After the investigation, if that house passes a resolution by at least 2/3 of the total number of its members, declaring that the charge has been sustained, then the resolution shall have the effect of removing the president as from the date the resolution is passed. Before entering office, the president or every person acting as president or discharging the functions of the president makes and subscribes in the presence of the Chief Justice of India, or in his absence, the senior most judge of the Supreme Court available, an oath or affirmation in the following form. I, A.B., do swear in the name of God. I, A.B., solemnly affirm that I will faithfully execute the office of President or discharge the functions of the President of India, and will, to the best of my ability, preserve, protect, and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of India. The significance of this oath goes beyond securing the personal loyalty of the President to the Constitution. It makes her him the protector and the defender of the Constitution. It was just stated that the President may be impeached on only one ground, that is, the violation of the Constitution. This oath precedes Article 74 that binds the President to the advice of the Council of Ministers. This means that the President is personally responsible to preserve, protect, and defend the Constitution, even though, due to Article 361, she or he may not be answerable to any court for such action. In brief, this is about the President of India. In my next talk, I will discuss about the Vice President as well as executive and legislative powers of the President. Thanks for patient listening.